some questions from the membership. Mr. Crew?
Good evening. My name is Michael Crew, and my law firm is Crew & Crew PA. We're in Fort Walton Beach.
Microphone.
Just a brief overview of my firm. The firm principals have been practicing law for over 25 years, first in Washington, D.C., and then we opened up our Florida firm in 1996. Most of our practice is representation of community associations, land use law, construction law, and complex civil litigation. We regularly work for and against associations, including Blue Water Bay, Seaside, Rosemary Beach, Fox Valley, Silver Shells, Marabella, and numerous others. These associations range in size from thousands of members to less than 100 members. Our attorneys have experience in the full range of association legal matters, including formation of associations, attendance at association meetings, enforcement of assessments, amendment of governing documents, and dissolution of the association. Many associations will often retain our firm to assist the regular counsel in complex matters.
Please enter your passcode and press the pound.
I apologize.
Can you pull the mic up to your face?
Sure.
Okay.
One moment while we try that passcode. Enjoy the silence till others arrive. Enjoy your meeting.
There were several questions that were sent in by the members that I was asked to answer, and I've grouped them into certain categories. And one of the most common questions is, what is the role of an association attorney? And the association attorney represents the association as a whole, not individual directors or individual association members. The association attorney takes instruction from the board of directors, and upon request of the board, the association attorney gives legal advice to the directors to help them make decisions for the association. Another common question is, why are some meetings, board meetings, closed to the association membership? And board meetings are usually closed when the board meets with the association attorney. And these meetings are to discuss proposed or pending litigation and are governed by the attorney-client privilege. So these meetings typically are if someone has threatened litigation against the association, or if the association believes that a certain dispute may lead to litigation, either sought by the association or sought against the association. And in order to have the association function as an organization, those communications have to be private between the association directors and the association attorney. Another common question is, what communications between the directors and the association attorney are confidential? And this is like the closed board meeting. Communications between the directors and the attorney are confidential when they discuss pending or proposed litigation. And these privileged communications include email, telephone conversations, letters, and documents that are prepared by the attorney or the directors relating to the proposed or pending litigation. So again, it's like the closed board meeting if we're having communications by email or by phone on the same type of subjects, and those types of communications have to be kept confidential. All right, another question is, was the FSR termination vote valid? And after reviewing many documents, it appears that the vote was consistent with the board's standard and usual practices. However, to resolve any doubt, the board should now vote to either ratify or rescind the termination. Another common question is, are board members allowed to attend board meetings telephonically? And the answer is yes. A director can attend a meeting by phone, as long as all the directors can hear each other, both the ones here in person and the ones on the phone. Another common question is, how are Holly by the Sea governing documents amended? And for this question, there are actually two parts, because you have the declaration and you have the bylaws. So for the bylaws, and amendment to the bylaws may be approved by either 2/3 of the directors and a majority of the membership, or another option is 2/3 of the membership. For the declaration, that has to be approved by both the majority of the directors and a majority of the membership. So I know there's a lot of people who have kind of a wish list or some thoughts about how the governing documents can be improved. And that's something that's always good for an association to look into. And we just need to make sure that we comply with the requirements for changing those governing documents. Thank you.
Take questions at this time or what?
I think all of the questions that I was supposed to be responding to were sent in by email. I think there was a deadline of last week for that, or Friday.
Friday, yes.
Will you take any follow-up questions to the answers that were provided?
It's up to the board if they want me to do any follow-up questions or answers.
We had a little bit more time. Is there anything else you want to say?
That's all I had. I think I dealt with all the questions that came via email.
How about not a new question, but a clarification of your response to what you reported to be a question previously submitted?
Okay, sure. Tell me what you have.
Okay, so you don't have to discuss with the members of the association anything that might potentially lead to litigation. So any subject could come up and say, oh no, because at some point in the future we might get sued, so we're not going to talk about it. Is that correct?
No, I wouldn't go that far.
Okay, that's what you said, but that wasn't the extent to which you said it, but that was a definition of what you said.
Okay. Was there another question?
Yes, sir. Along the same lines, at the last business meeting, I asked Mrs. Crawford to post the emails that she has presented to FSR, because we are the client of FSR, all of us. And there's questions as to what was asked as far as communications. Her response as to why that has not happened, an attorney told her not to post those emails so that the membership can know what she has requested from FSR.
All right, so let me talk with the board on that and see which emails we can release. So some of them should be kept confidential, but I think there's some that we can release. So let me make a note and I'll have that discussion with the board.
Specifically, sir, what we're looking for is what has the board requested from FSR, what changes, anything with the contract to mitigate what they're saying is extortionate costs. Has there been any communication along those lines? We want to know, because most of us can't trust either one of these two board members.
Okay, all right, thank you.
You had stated that the board actions were in accordance with board practices, but the decision would either need to be ratified or rescinded. So why would it need to be ratified or rescinded if it was in accordance with board practice?
Right, actually what I said is that to avoid any doubt on the issue, I don't think that it needs to be ratified or rescinded, but in order to clarify the vote, I would recommend that it be ratified or rescinded.
So,
but there's no need to do that.
So could that decision on December 2nd be successfully defended if legal action was brought against in accordance with whatever law you think?
Based on the information that I have now, yes.
May we ask what that information was?
I think that would be getting into confidential information at this point.
I'm just so confused because the actions were public, but then it seems that now it's being couched as private. So it seems the actions were public, but now they're being couched in the umbrella of client privileged, client attorney privileged information. But does the association not have a right to know the actions that led up to that? I mean, what transpired leading up to that meeting?
And I think there's two issues that are going on here. One is the actual facts that may have occurred at meetings or that may have occurred with FSR or with the board. And those facts that are already public are of course public. Those don't become private just because they're maybe the subject of a future dispute or something like that. But as far as the lawyer's analysis of those facts in terms of the law and basically applying facts or the law to the facts, that's the part that's confidential. That's attorney-client privileged information. And certainly any type of discussions that I've had with the board about that topic at this point would also be confidential. So it's not the facts themselves that are confidential, it's the analysis of the law to the facts, and then any type of communications I've had with the board regarding this issue.
So then the actions that were taken at the December 2nd meeting were legal?
I think I've already answered that.
The changing of the agenda and the way the discussion was changed to a motion to terminate, that was legal?
Is that the same question you asked previously?
It's just yes or no, it was legal?
Okay, based on the information that I have, it does appear to be a valid vote.
Okay, I was just wanting it to be based on the actions that actually took place.
I think there's another question.
Yeah, you've answered part of this, but could you just go into further detail attorney-client privilege? Because technically, you stated that you represent the membership under the direction of the board, but is attorney-client privilege just a term that's going to be thrown out there anytime the board wants to sanitize or cleanse information that we have the right to know? I mean, you represent us, you don't represent anybody at that table.
That's not what he said.
It sounds more like an argument than a question.
No, it was a question. I asked you
Yeah.
to go into further
Okay.
detail about that and how that term is going to be used going forward. What's the consistent use of that term going forward?
If asking me if I can predict the future, the answer would be no. I'm not going to be able to predict how that term is going to be used going forward.
Well, you should have a standard as to how that term is going to be used and how it's going to be enforced. Is that not correct? Has that not been discussed?
Well,
Because
it
it
has been.
sounds like it has been.
All right, wait. Let me just answer that fellow's question there, because you're asking so many. I can't pin you down long enough to answer your question. Go ahead, sir.
It's very specific.
I think sometime in the near future, that maybe the board can come out here and have you to explain to the membership what the board of directors' responsibilities are as board members and what the responsibilities are to the membership. Because I, from listening to people talk for the past few months, we have a lot of people who thoroughly doesn't understand our covenants and bylaws and who has the authority here or there. And that's why I think we're getting these questions, that should be in the near future cleared up. Thank you.
Yeah, and that's something that many associations do ask the association attorney to have a short session with the membership explaining the different obligations or duties under the governing document. So I'd be happy to do that if I'm so directed by the board. Yes, ma'am.
Do board members have a fiduciary duty to disclose any potential conflicts of interest prior to voting on an agenda that they feel might influence them in one way or another?
Board members do have a fiduciary duty to the association and to the membership. There's no doubt about that. Part of your question involves how remote a potential conflict might be. But certainly, if it's a likely conflict, then the board member should disclose that. And if it's a present conflict, then the board member must disclose it.
Thank you.
Yes, sir.
Mr. Mike Cruz, if the board you work for the board, and as a homeowner, if the board's actions decreases my property values or damage me, do I hold the board accountable or do I hold my homeowners association accountable?
That's a very broad question.
Broad?
Probably already know that, but it would depend on the action. So if it's action taken by the association as a whole, then maybe you would look to the association for that if you had a cause of action.
So if the board is acting not in my best interest or the homeowners association's best interest, but in their own personal interest, then I could hold them liable because what you're saying is they're separate than us. They're the board, we're the homeowners.
I'm not sure what you're asking now, but
I'm asking that if my property values go down based on the actions and where this board is leading this association, who do I hold accountable?
again, that's a very broad and vague question. I'm not sure. I would have to know more facts about
Anybody ever think it's late?
what the wrongful.
I would disagree direct. But then I'm not an attorney.
How much more time do you? Just tell me when I'm done.
I'll tell you in a
Okay, all right. Yes, ma'am.
I just wanted to verify, you said you received all the questions and you answered them all?
Yes.
Okay.
Are there some other questions that I think we're
None of
kind
mine
of?
were answered, so I'll find out why they,
Well, here's a whole list of what was submitted.
Yes.
none of mine were answered.
I specifically asked a question, and I referenced the secretary's duties. I referenced paragraph 8 of the FSR contract, the notice, and who's supposed to, that the secretary, from what I understand, is supposed to do all notices required by law. And at the last special meeting, Mrs. Crawford mentioned what was asked, and she said that she prepared the letters or the notices to FSR. I'm wondering if that is a problem, since they were not prepared by the secretary and probably don't have our seal on them.
As I understand your question, you're asking if the notice of termination sent to FSR was proper because it was issued by the president and not the secretary?
Yes, sir.
I don't think that makes a difference, but I haven't studied that question, so. But typically it does not make a difference. It's often the president who would issue letters, sign and issue letters like that.
Who vetted the questions before you received them?
I received them from Ms. Fambry, as I recall, and I looked through them and then put them in the categories that I went over there at the start of my presentation. If somebody thinks that I missed your question, now would be the time to ask it.
Well, I'm going to assume, since many of us specifically asked if we should fear litigation from the management company because of the actions of the December 2nd meeting, and that question was not answered directly, so I'm assuming you're using the confidentiality issue because you didn't directly answer that question that was asked, I know, by multiple people.
Tell me the question and I'll try to answer it now.
Should the association be concerned about legal action by the management company because the termination on the December 2nd meeting was very questionably done to most of us? We believe that it was not properly done, particularly with a board member that was not called in to the entire meeting, had to be called back to vote, and they already had a termination letter prepared, like they knew they were going to do it, even though the initial agenda only said discuss.
There are actually several parts to that question, but let me answer the first part, which I think is your main part of the question, which is, could FSR sue the association regarding the termination? The answer is yes. FSR could. Now, are they likely to? I don't know. I have not been served with a notice of intent to sue or something like that, and I don't know if that's on the. I don't know if it's in the mail and it's on the way to my office, or if it will never come.
Well, I'm assuming since you didn't answer that question that many presented, I assume it was because you thought it was possible litigation or probable litigation.
So at this point, if litigation shows up, it's going to be a complete surprise to you.
If FSR sues the association?
Yeah.
Well, I think I just answered that, so
Don't
I
they
want
answer
to say
yes?
something.
I would say, how concerned are you if we do get sued by them, FSR? What would you say to the board if that happens? How concerned are you that we would win or lose the battle?
Based on what I know now, based on the facts I have now, I think that that the association would win that lawsuit. So I don't have a high level of concern, but I think the best course is to try to avoid litigation because it typically delays the association's progress forward, and of course it's expensive. And so I would try to do everything reasonable to avoid the lawsuit. Yes, sir.
I have another question. Notice we only have 3 people here and 1 person on the phone, but we're supposed to have 5 board members. How long should we wait before they sit a 5th board member?
Who's on the phone?
Who's on the phone?
There's no one on the
They got the phone turned on.
Okay.
We don't know if anyone's on.
I guess, I don't know if Rebecca's coming or not then.
She resigned.
As secretary.
Okay.
As secretary.
I'm not sure what your question is.
Well, now we have 2 vacancies apparently. How long should we wait? I mean, we've got ballots coming in with we got people with over 1,600 votes that should be seated in those vacant seats. Why aren't we putting people in those vacant seats?
I would recommend that the openings on the board be filled immediately, as soon as possible. So.
And now we're in our 3rd month since the last person resigned. The first person. Well, no, that would be the 4th person resigned. Three initially, Miller, and then this, and then the 5th person.
Can we just have order one question at a time? Does anyone have a question for Mr. Crowe?
I just have one question. Could you give us an estimation of the average legal cost to an association if we did go into litigation for something like this? I mean, I know there's, I'm sure, a broad range, but I think that's one of the biggest concerns that, the membership has is what would this cost us? I know you're saying I would try to avoid this at all costs, but
It would lawsuits typically cost between $1,000 and $100,000. And that's about the most narrow I can give you at this point. Many lawsuits are settled right after the lawsuit is filed. And so, in that case, it'd be closer to the 1,000. If the lawsuit goes all the way to trial after a very long period of discovery, or maybe after several years of numerous hearings.
So I guess you're just talking about legal fees, but I guess what I'm also thinking too is, there were damages or something had to be paid. Let's say in the case that we're all worried about is 2FSR. I mean, the contract, I'm sure they would want the remainder of what we had, whenever we initially signed it, what it's worth to them. So on top of legal fees, is there an additional number?
I wouldn't be able to speculate as to what FSR's damages could be.
Right.
And I don't know what they would seek. So there's no way for me to know what FSR, if they ever filed suit, what they would seek for damages. I don't know if it would be a small number or a large number. It's just hard to.
Potentially, we could be on the hook for a lot of money.
I don't see how you would be on the hook for a lot of damages. No, I don't see that as being likely, certainly.
But we would be on hook for legal fees at a minimum.
Potentially, again, it's not something that I've investigated because this is a speculative event that hasn't happened yet. So
right, I know, and I mean, it's just that if anybody, people avoid lawsuits because of that exact reason.
Exactly, because of the unknown, right?
Right.
Which is always a good reason.
Even though you think you've got a slam dunk case, maybe it's not. So that's why everybody's here, because they care, not because they're trying to attack somebody. But we have great concerns. So we really appreciate you being here and introducing yourself.
Thank you. Yes, sir.
I have a question. When FSR leaves, if there are some open-ended legal issues, who would be responsible for them? I mean, once they leave here, that doesn't alleviate them of legal problems, does it, that they created?
I'm not sure which legal problems you're talking about, but but I think I can say generally that if FSR leaves, that doesn't eliminate all legal problems. There could still be some claims, but that's what you're asking. Could
Yes, that's
FSR
what I'm
leave
asking.
and then make some claims later? Yes, I think that's possible. I don't know if it's likely, but it's certainly possible. And then, I guess on the other hand, it could be, if FSR leaves, then Holiday by the Sea could make claims against FSR after the leaving too. Yeah. Yes, sir.
Yeah, did you advise the board that if an item is listed as a consent item, that members are not allowed to speak to that agenda item, even though FS 720 states that members may speak to all items on the agenda?
Let me answer that question backwards and say that you are correct that 720 says that under certain conditions, members can speak on items on the agenda. So I would not give advice different than that. Whether it's a consent item or not, that the members have the right to speak on the agenda item as is described in chapter 720, and it doesn't make no difference whether it's consent or not consent.
Okay, be advised that at our last meeting, the board president stated she was told by legal that members did not need to be allowed to speak if the agenda item was listed as a consent item. Be advised. And that's on video.
I haven't seen that, so I can't comment on that. Yes, sir.
You mentioned during your dissertation that the board member has to be advised with a singular statement. Does the board member include all of the board members?
I'm not sure what you're talking about.
There were 4, there were 5.
I think everything I've stated so far as the duties of a board member would apply to all the board members. I'm not sure what you're asking.
I'm asking if information comes to one board member and it is not passed to another member, is that a problem?
I would need to know what the information is. Is it the information that it's going to rain tomorrow? Is it information that there's a board member who's getting personal checks out of the association account? It varies. It certainly.
Holiday by the Sea business, anything that deals with Holiday by the Sea business. If
No.
one person gets it on the board, should that be sent out to all board members?
I'm still not sure you're asking. You're saying that if a member sends something to the board of directors, should the member send it to all the directors? Or if you're saying that a director discovers some information, should they then immediately go to the other directors and give that information? Is it the second example that you're talking about?
Yes.
Probably, yeah.
Okay.
Basically, we're trying to find out,
Right.
one board member gets information, but they don't share it with the rest of the board, even though it could affect a decision that board member may make.
Right. Well, there's a lot of information that the board members have that will be difficult to share. All of that with all the other board members. So we can't have a rule across the board that every little bit of information that one board member gets has to be disseminated to every other board member, because then your meetings would last 10 or 12 hours every time, because each board member would then have to say, let me run down the list of everything I've discovered in the last month or last time since our board meeting, since our last board meeting. So there's not an obligation to divulge everything, but if it's something material that's important, and certainly if it's something that's maybe damaging to the association, or then definitely yes. So it's kind of a scale. If it's kind of trivial information, or it's something that maybe management is taking care of, and the board member feels like it's being handled by some other part of the association, so it's not that important, and that doesn't have to be shared with every director. That would just take too long for every meeting to have to go through all that type of information. But if it's something kind of on the other end of the scale that's very important and would be damaging to the association not to tell the other directors, then there would be definitely a duty.
Such as the plan to terminate the management company?
I don't know. Keep in mind that I've just been working for the association here, a few weeks. if you're going back to what happened last year, I don't have full information about that. Yes, sir.
Mr. Crowe?
This might have been,
This should be the last question.
Okay, all right, thank you.
this might have been addressed, I don't know. It's a two-pronged question. Number one, if sunshine law has been violated, does the association come under the sunshine law?
The answer to that is no.
Okay, you answered it,
Yeah.
and I will have to pursue it.
Right, sunshine law just deals with government agencies. Now that's typically, when, association members talk about sunshine law, they're talking about the obligation to have association business conducted at association meetings, which is kind of loosely called the sunshine law, but it's not. The sunshine law just deals with government entities. So if kind of part B of your question is, should association business be conducted at association meetings? And the answer is yes. There should not be decisions that are made outside of meetings. Certainly if they're important decisions. If the question is, if there's a board member walking by and somebody's doing some painting and says, do you want me to paint this area over here? Then the board member can say, yes, that looks good, go do that, without having to have a full board meeting. So again, it's kind of a scale of decisions. Minor decisions, some of those can be made outside of meetings because that's the only practical way to do it. Major decisions should be made only at meetings.
Since they brought a prepared letter that 3 of them were already had agreed upon and the other 2 didn't even know that was coming up at that meeting, and they came with a prepared termination letter with 3 of them, to me that seems to fall there.
Thank you very much, Mr. Crowe, for speaking with us. Perhaps you'd stay a little while.
Sure, okay.
Thank you. Okay. We ran a little over. I call the meeting to order, time 6:02. Okay, will the directors please call the roll?
Jeffrey?
Alex Crawford?
Bill Crouch?
Thank you. Has the meeting been duly noted?
Yes.
Can I have a motion on the agenda? Can you hear?
No.
No? Can you hear now?
No.
Can you hear now?
No.
I don't know, she's trying now. She's not a director. No, she resigned.
She wanted to try this one?
Resigned.
You're not gonna answer any more questions.
Please sit down.
Oh, really? Try that one.
This one?
Oh, yeah, try that one. You keep turning it off. You keep leaving it, there you go.
Testing.
Okay.
Okay, can I have a motion to approve the agenda?
I'd like to make a motion to amend the agenda. I would like to amend the agenda. It looks like it's like a 2 or 3 hour agenda, and I'd like to amend it by removing the open forum, item number 11.
I second that. We've got some very important things. Excuse me, please. Will the meeting come to order? We've got some very important items tonight, and 9 o'clock, the recreation center closes. So I think we'll be lucky to get through exactly what we've got. Can we have a vote on Mr. Crouch's motion?
Can I make a comment, please?
Certainly.
Thank you. You might want to start the timer, Mr. Crouch. Number one, I'd like the board to consider postponing FSR's termination until the association.
We have a motion on the floor. If you would like to talk about that motion,
It is about the agenda, sir. I'm asking that you amend the agenda.
We have a motion.
We have a
to
motion.
amend
If you would
to
like to
amend the
discuss
agenda.
that motion, we'd be more than happy.
Okay, sorry. No,
The motion before the board is to amend the motion and cancel item number 11, the open forum.
Thank you for correcting me. I would say open forum should be let because the members need to have the opportunity to say whatever happens to be on their mind, even though that seems we don't get to do that.
Thank you. can we vote on Ms. Crouch's motion to remove the open forum from the agenda tonight? Will those in favor say aye?
Aye.
Aye. Those opposed say nay?
Nay.
Okay, the agenda, the item of the open forum to move from the agenda 2-1. Can I have an approval of the amended agenda, please?
Aye. I approve.
No. Can I have a motion?
I have a motion to approve the amended agenda.
I second. Didn't you want to make?
I'd have to wait for the proper time.
Okay, we have a motion, a second to approve the amended agenda.
May I have the floor? Thank you. The timer's been running, so I asked you to flip it back over, so it's not, okay. Number one, and under new business, I ask that you add to postpone the FSR termination until the association has developed a proper business plan for transition. We have a timeline. We do not have a plan. How many people are we going to be hiring? How many full-time? How many part-time? How many volunteers? What's the threshold we're going to have? Should we not get enough volunteers, so we're going to start hiring either part-time or full-time people? What are their salaries going to be? The board has not approved any of this information before my eyes, and it is something that should be done publicly. What is our budget going to be? How much are we going to be paying for all the different items? Where are we going to be putting our money? Who's going to be managing our money? All these questions should be answered in a business type plan that would be addressed. That's number one. Number two, as the lawyer said, we need to seek Pete, Rod, or Bob. So I ask you to add an agenda item to add 3 members to the board, or 1 or 2 members to the board, either Pete, Rod, or Bob. And one of those guys has got over 1,600 votes. They have been vetted by the community, better than anybody else has been vetted by the community. Any questions that one might have should be done. And then lastly, ratify. Please put, well, if you're not going to put another person on the board, it's a moot point because you've got 2-1. It's not going to, we already know what's going to happen. But without having a good transition plan, we are putting the trailer on the wrong end of the car as we're driving down the road.
Thank you.
Thank you for the disaster we're about to have.
I would ask the membership to please refrain from personal remarks tonight. We have a guest.
Excuse me.
Please sit down, sir.
Was there a personal remark in what I just said?
Yes, sir.
Where was the personal remark?
So please sit down.
Where was the personal remark, please?
At the end.
Yeah. We have a motion on the floor to approve the amended agenda.
Wait, can I say something, please?
Is it about the amended agenda?
It's about amending the agenda. I do agree that we need to seat 2 more board members to ensure that there's a full board. And again, there have been 3 names, and Pete Washenko is one of them. He's worked on the architectural committee. He's very well familiar with the process. And I think it is important to maintain the integrity of the board, that those 2 seats be filled before any business be conducted tonight. Thank you.
Thank you. Okay, I have a motion and a second to approve the amended agenda. Those in favor?
Could I ask a question first, please? The last gentleman up here made a motion to have 3 agenda items under new business. Should we not?
No.
We don't have to vote on those?
No, not at all, because
Why?
the board are the ones who make
Is
the
it the board that can
motions.
are they the only ones that can modify the agenda?
Members cannot make motions, only directors can make motions.
Okay, sorry about that.
Okay. Did you have another amendment of the agenda? I thought you were speaking.
Could I simply say I'd like to amend the agenda according to what Mr. Carson had just said? Make a motion to amend the agenda according to what Mr. Carson and Ms. Harper had just said.
He can read it again for you.
Okay, those in favor of a further amendment of the agenda, or do you have a second? Do you have a second? Okay, do you have a second? No? No second. Okay, we will return to the motion that is on the table. The motion on the table is to approve the amended agenda. Please order. Order. Okay, those in favor of approving the amended agenda, please say aye.
Aye.
Aye. Those opposed, say nay.
Nay.
Okay. The amended agenda is approved 2-1.
And she says that she was on.
Okay, we come to the approval of the minutes. Can you click on please? Go on. Go. Okay, we have several minutes to be approved, but because we no longer have a secretary, we will table that for the first available opportunity.
That's postponed or tabled, doesn't table come at the end?
It will be postponed until we can actually get hold of the minutes and see where we are on the minutes. I think we have some minutes. I'm going to get with the GM tomorrow to find out exactly what we've got. Okay, the GM report, first service.
No report tonight.
Thank you. Officer report.
Are you on your way? Are you coming?
All right, treasurer's report ending January 31st. Operating cash available, $1,345,590. Undesignated funds available, $617,620. Reserve, the restore replace as of 1/31, $820,704. And as you know from previous meetings, I always deduct out certain items. The portion for capital improvement is $317,826. The portion for the maturing CDs is $257,333. That gives us available for reserve cash $245,545. And I'd just like to point out that we do have another $130,167 of reserve funds, which was deposited in February. This is January's report, but I like to tell you what something is in real time, especially that particular number. So actually, at the moment, that reserve cash number in real time right now is $375,689. That's that. What do you want? Oh, okay. Okay. We have been reporting on the percentage of assessments received. So to date, and we did send out reminder notices, so to date we have received 88% of assessments for 2015. Okay.
Jan, could I ask you, is that normal compared to last year and the year before? Or?
When I asked the question, I was told this was off the cuff. They hadn't gone back and actually computed it for me, but they're thinking that it's running about, having received about 10% more than normal by this time. All right, okay. The other thing is our auditors, that's Carr, Riggs, and Ingram, gave us a clean bill of health once they completed our audit. I signed all the tax papers, and I'm recommending that we accept the audit. And I guess you and I will sign it? Okay, and recommend that the President and myself go ahead and sign it. Okay, thank you.
Could I ask a quick, we don't have to vote on that, we just have to.
Correct, we don't have to vote on that.
Okay, external vice president? Yeah.
I have no report.
I have posted a meeting for Thursday, President's report, to select two replacement or to select replacement board members. We have some decisions tonight we need to make to move forward with the transition. I've been working on the transition. That's all of the President's report tonight. Now we come to the architectural variances.
I have a comment on the President's report. You just said that you posted a notice. Is there not one position that you're prohibited from filling, according to our covenants and bylaws? The secretary?
I'm gonna defer to our attorney on that one.
And then the secretary has to post notices? According to, that is specifically in our covenants and bylaws?
What is the question? Can the president post notices in absence of the secretary?
The president is prohibited. Yes. The president is prohibited from fulfilling the job of the secretary. Thank you.
The lawyer needs to see what's written.
Who's gonna do it?
Is it secretary's job?
Can you tell us what time the meeting is? And that's just select community board members?
Just select board members, I think it's posted. What time did you say?
I mean, I don't know when you posted
The
it.
president shall not also be the secretary or assistant secretary. It's right here. Shall not. And then here's the duties of the secretary. The president, as far as my point is, the president cannot post notices.
It has to be another member.
Well, actually, it was the general manager who posted the notices. I just applied the notices.
I think there's ambiguity.
You still need this, Mr. Cruz?
No. Should we move on? We'll move on. Okay, we have the chairman of the ACC.
What time is your meeting Thursday?
6.
6 o'clock.
P. Washenko, 2532 Sucker 27. Motion to accept and discuss model home policy. Does everyone have a copy? Basically, you guys just refresh your memory, you asked the ACC to try to come up with a policy for model homes, and we sort of did. We reached out to the back and to Hidden Creek Estates. Basically, we just came up with a couple key points, and I'll just say them briefly for the audience just so you could hear it. Basically, new proposed model homes subject to new residential structure application will be reviewed and location approved by the ACC committee. Location of the model home should be on Sunrise from Navigator south to Highway 98. Model home parking will be provided at a location to accommodate no fewer than 5 mid-sized cars and to be accessible from the road. And signage and maintenance of the model homes will be followed by the sign policy and maintenance policy criteria, and in compliance with Santa Rosa Code. Basically, any kind of the maintenance we left off. We just wanted to bring it, the maintenance policy be mentioned. So there's no difference between a model home and a regular home. That's basically it.
Okay, can you explain why we need to have these model homes? I mean, Sunrise is already a kind of thoroughfare, and we have the school, we have 3 model homes there.
Basically what happens is we've had 2 or 3 builders ask us to build model homes, and there are no policy in place. So it's my job to come to you, and you send it back to me to come up with a policy.
Have you inquired of the residents of Sunrise whether they're amenable to having a model?
As far as I know right now, there's only 2 lots available on Sunrise.
I'm saying the existing residents, have you asked the existing residents? I mean, I wouldn't like a model home where I live.
Right now, that's where they are. They're not from Navigator to 98. There's probably, I think there's 4 or 5 right now.
My question was, have you asked the residents of Sunrise whether they approve having more model homes there
No, I
or
have
not? Okay. I think in fairness,
I have a question. Just recently, we've had a problem with model homes. I'm not sure the builder, but the builder sold his model home and then built a new model home, and there was a problem with that because they didn't want model homes built there, and that was one of the problems. They didn't want them on Sunrise, and he built one, and somebody on your architectural committee, I'm not saying the people there now, somebody approved it when they shouldn't have.
Right now, I think the problem is there is no policy. There's nothing in the covenant that says anything about model homes. So when someone comes to me and says, what about a model home? Can I build it there? Is it my job to say, no, you can't? It's not my job. It's their job, the board, to come up with some kind of policy. If you want to say right now, no more model homes built, do it.
But I think it was also your job not to approve it.
Excuse me?
It was also your job not to approve it.
Correct. Well, there has to be policies in place. Right now, there is nothing in place. There's nothing in place right now.
Should be.
Sure there should be.
Architecture committee should have submitted one.
Here we go.
But what you've done now is a little different, because what I told you, past practice, not policy, was no model
So
homes.
what you're saying, learn from your mistakes.
Well, I think you should.
Right. Remember that.
Okay, not a discussion, please. Okay, I think the fairest thing to do is to find out from the residents of Sunrise what their view is on this. Because it's their street that's being turned over to commercial traffic almost. Before we make a policy, let's find out what the people of Sunrise want.
I do have a question. Does the architectural committee work for the homeowners of Holly by the Sea? Is that who pays them? Or do they work for the builders of Holly by the Sea, and do they pay them? Could you answer that?
The architectural committee works for the members to try to enforce everything that is written.
Well, I just want to know. So they're the ones basically the builders stuff.
Absolutely.
Thank you.
Hey Pete, isn't there a street, isn't it Water Street, that is zoned commercial properties?
Yes.
Yes.
R2.
What's the problem with building something there rather than on Sunrise, which is basically zoned residential?
Right now, there's nothing, you could put it anywhere. It's up to the ACC to approve it.
But why
But there's
don't
nothing
put it
written
anywhere?
down. We're trying, I don't think you can get any more narrower than this. There's basically 2 lots left.
Sir, is that not a commercial enterprise? Building a home, model home?
I don't believe it is.
I believe it is.
It
is. It is commercial enterprise.
Okay, can we speak one
I'm not
at a
an
time,
expert.
please? One at a time.
Jan, I think you were gonna say something before.
Yeah, I was gonna say, to keep saying, ask the neighbors on Sunrise, do we wanna make a question like this neighborhood specific?
I don't think so.
Well,
It's gotta be a policy, I think. I don't wanna run into this, we've talked about, exceptions and making mistakes because we make exceptions. I'm thinking if we're gonna go street by street, we'll probably cause ourselves problems, because that's my street and not my street. So I guess I'm just saying, if there's going to be a policy, you seem to be indicating you wanted, neighbors on a specific street to be asked. I think this type of policy would have to be community-wide if we had it, you know?
yeah, even though they're only supposed to be on Sunrise, but I take your
there's a rule
point.
that says that?
Yeah, that's what he's saying, that they're only gonna be on Sunrise. That's why I said Sunrise. I mean,
There must be some rule somewhere originally that said that they could be on Sunrise.
No.
There's not?
No, and again, back to what you mentioned, there is an area, you mentioned it, there is an area that is in fact rated for commercial. It's the only one in Holly by the Sea, just that one area. There were model homes.
It's actually more than that, but to let you know.
Pardon me?
There is more than that.
Okay.
Up on 399.
Maybe yeah, okay. You might be right. The point is that model homes were in other areas besides Sunrise. There were areas over in the middle of Holly by the Sea that had model homes, but they told them to get rid of them, no more, and now you have commercial property that could be purchased.
We can modify it. You want it up on 399.
Do you want to speak? Can you come up to a microphone?
Oh.
For 20 years or more, we've always had a policy, I don't know what went with it or the paperwork, that the only place we had, or they let people build model homes, was on Sunrise. I think in the last 20 years, they've only been, I don't know any about in the middle of the community, but there's one exception that they had one model home at the corner of Edgewood where your sign is. Other than that, that's the only, it was wrote right in with, and I'm sure when they go through the paperwork, the attorneys, they can find it. That's the only place that you can build a model home, is on Sunrise. Now, I don't like the ideal of you saying, I'm gonna go and ask my neighbors, is it okay for somebody to build a model home beside me? That's you folks' job to make that decision. Maybe the neighbors don't like the guy, or maybe they do, but that's a board decision. It shouldn't be the architectural committee running through the community and asking people about this. Our policy's been, I know for 20 years, Sunrise only. There was a couple exceptions in 20 years, and other than that, that's the only place I know they've ever had one. Thank you.
I think I could dispute that. I don't know if I can prove it, but we bought in 1980 something, 86 or 78, somewhere around there. And I believe that the street we looked at, model homes, was valid.
That is exactly true, and that's when the developer had control. He could build them on top of each other. But since we left our policy for the past, since 2000 or so, that's the only place, and the developer had went into that mode too. But they could have been, he had a trailer over there at one time, as you recall too, on the corner of Water Street and Sunrise. But you can't put a trailer over there. Thank you.
Mr. Mosier's home is a model home, and it's right in the middle of Holly's by the sea.
A what?
Mr. Mosier's home was a model home, right in the middle of Holly by the sea.
I'd like to have a brief recess in this discussion because you were trying to get the phone to work earlier, and I checked my messages, and I know Alex also got a message that Rebecca was trying to call in and the phone system doesn't seem to be working. So you were trying to get the phone system working. She's been on my phone listening on speakers since the meeting began. So I was just wondering, and you keep talking about needing to replace 2 positions, so I don't know what's going on.
Yeah, I think we need some clarification. My understanding is Rebecca Ward resigned.
Do you have a resignation letter?
Yes, I do.
Could you read it?
Email.
Rebecca, I'm going to put you on speakerphone. Can you hear me, Rebecca?
Okay, effective today, March the 9th, 2015 at 12 noon, I hereby resign my position as Secretary of the Board of Directors for Holly by the Sea Improvement Association.
Okay, that says she resigned as Secretary.
They get paid inside, those people get paid.
Semantics, I accepted her resignation.
No, they do.
As Secretary?
I accepted her resignation.
Okay, it says she resigned as Secretary, not as a board member. Can we get clarification from the attorney?
I understood that she resigned from the board.
Did you talk to her? I mean, in the letter it says she resigned as Secretary.
I did talk with her.
So but is she resigned as Secretary? Because we were trying to call her in tonight.
He's already answered that question. It's his understanding that.
Have Rebecca answer.
Rebecca, are you there? Did you resign from the board or as Secretary? Is it just a clarification on your resignation letter? Okay, so.
He's already given his clarification.
On the resignation letter.
Yes.
As the letter stands in writing, did she resign from the board or as secretary?
I already answered that. Do you want me to answer it again?
Please clarify, yes.
In
My
her-
understanding is that she resigned from the board,
Based on the letter she sent.
based on the letter and based on my communication.
Thank you.
Karen, can we move on to our motion, please?
Sorry, Pete,
Yeah.
we're still on the model home. Okay, do we have a motion to approve this? Do we have a motion to approve the model home policy?
I make a motion, we approve the model home policy.
Do we have a second? Okay, the motion fails for lack of a second.
Point of order.
Yeah. Well, then you second it. You guys are the ones that wanted it from there.
Well, your motion was to approve it.
Yeah, okay. Your motion was to approve it. Your motion was to approve it, you can get a second.
I'd like to talk about it some more, but.
Oh, okay, well then talk about it.
Okay.
I thought you were done.
There doesn't seem to be any kind of rules in anywhere that we can find that area was established by, after the developer left, that area was actually established as a commercial area that you can do model homes.
Correct.
Now, years and years and years, I mean, I've been here for 23 years, there's always been model homes there. And there were actually some more when Jerry Blake was here. There were several on the board, but he sold all those. And it would seem like to me that I mean, I'm all for realtors and builders having an opportunity to sell a home in our great community. I mean, I'm all for that. But it would seem like that would have to be in the covenants or something for us to approve something like that. Am I wrong? Mr. Cruz, is that something that the board can just say yes, or it's okay, or no, it's not, or what?
I haven't researched that issue, so I don't know the answer to that, but I'm thinking the board could probably adopt a policy, but I can research that and give you an answer within the next week or so.
I think it's not a bad idea to actually.
I think we already have a policy, don't we? But it's just not in written.
We don't have
We
don't have a policy.
There's no policy.
Well, there's homes there, so obviously somebody has granted it at some point.
Because on the application, new home application, there's a spot that says this is a model home. So right now, you could probably theoretically put them anywhere. And if the architectural department approves it, it's in.
I see, so we really need to define the numbers and the spots.
If you want to control it better.
Well, I think we need to, wouldn't you think?
That's why I'm here.
Okay.
I don't think you can get any more narrower than what we just did from Navigator Street to 98. I'm telling you, there's only 2 lots left. Now, if you want to open it up, then it's not a bad idea to residential / commercial, exception C, of the covenants. That's not a bad idea too. So that's all of the waterfront on 98 side. On 399, there's probably about 6 lots.
Well, it's commercial in such that it's multifamily residence.
Multifamily, yes.
Or
Multifamily is not commercial. Please, if anybody wishes to speak, can they raise their hand, come to the podium, and they can address the meeting.
Pat Trainer, I tend to agree with, when you talk about the word commercial, that area was meant for business. If you wanted to build a business there, people decided to build homes there instead. But the fact remains that building and a model home is in fact a commercial business. It's not a hobby. So it should be put in a commercial area. My understanding, for as long as I've been around here, the model homes that are here now, they were told once they sold them, that was it, they weren't going to build again. And then there was a problem because somebody built one, okay? Then they sold the other one and they already had permission. And there was a problem with the board. So what I suggest is to approve it for commercial areas. and then you would not have the problem of a builder saying, well, you let Sammy do it, but you didn't let me do it.
Well, the builders may not have property on that commercial road. Only one road is commercial?
They may not have property anywhere, but what I'm saying is that's where they need to buy if they want to build a model home. That's my suggestion.
How many lots would still be available?
There's actually more lots on Water Street. I would have to count, but there's probably about 8, 10, and I think up on that 399, I think there's 3.
Okay, do I have a motion to accept this, or do we want to postpone it to another meeting, think about it?
Tell me what you want.
Excuse me, please, do you wish to address the?
I was just giving him some more information for you.
Right, Beth was just pointing out the lots on 399 are the ones that are in the Exhibit C, that is / commercial. So that is actually, for people that don't know, right past Hidden Creek, if you're going past the entrance, on the left, the next, looks like almost 10 lots, 11, maybe actually more than that, 1, 2, 3, 4, 5, 6, maybe like 12, 14 that are commercial. I don't know, I would have to research how many actual homes
This is
there.
on 399?
399, actually, that's one of the multifamily lots that had a single family. Remember last meeting I said there was a single family lot built, a single family home built on a multifamily lot, but it slipped through, because there's nothing in place, so it was never picked up in the architectural department. That's why we're changing the new application to have this stand out.
I see.
I make a motion, we postpone until the attorney offers an opinion.
I second. Okay, it's motioned and seconded to postpone this item until the attorney has had a chance to give us an opinion on this. Those in favor, those in favor of postponing the motion?
Aye.
Aye. Those opposed? I guess one abstention. So it is passed to postpone the discussion until we have some clarification from the attorney. 2-0.
I just got one comment. That property on 399 is not listed in the county and it's not commercial property.
Thank you. Okay, will you move on to item B?
Discussion for the new parking policy. Basically, the new parking policy, there's 2 additions that reflect in back. There's an E and an F. Number 3, basically a permit is issued for dumpsters to be stored on the driveway. Time duration will be set in discretion of the ACC. And F, a permit may be issued for portable storage containers for up to 2 weeks to move in and out of the property. The permit may be extended or accommodate extenuating circumstances with the ACC's approval. Basically, we just needed something else. People use the storage pods to move, and there's nothing on our parking policy to enforce anything, so we just need something in here to help us out. So let's just say someone's moving, or someone's doing renovation, and they want to use these pods for storage to put their stuff in, which is well and good, but there's nothing, so let's just say it's on their driveway now for 3 months. There's nothing for our violations to go out. We have nothing in the covenants that says anything about storage containers. We need something to enforce.
How long can they have on the short term?
Short term, 2 weeks.
Okay, if that were not long enough, would that be extended?
That's what it just said, yes.
Okay.
With a permit to extend it. So
Okay.
like if there's a flood, absolutely. But at least it gives us a basis.
I make a motion that we accept the revision to the parking policy to include short-term permits of dumpsters and portable storage containers.
I second it.
It's motioned and seconded to accept the revision to the parking policy to include short-term permits of dumpsters and portable storage containers. You ready for the question and discussion? Those in favor?
Aye.
Aye.
Aye. Okay, it is passed to accept the revision to the parking policy to include short-term permits of dumpsters and portable storage containers, 3-0. You wanna go on?
Yeah, actually, I just want to go back for a second to the model home. Do you not want the ACC to do anything with the model home until the lawyer takes a look at it? Is that what you're telling me?
Correct.
Okay. All right, motion to approve a variance in retro for 2040 Jamaica Drive fence smooth side. It's next to a chain link fence. So basically, this is a brand new home, and the builder put up a fence smooth side in because of the chain link fence. You have a picture of it? Yep, there it is. If it helps, you also have the picture of what it's actually hiding. Mr. President, you have a picture of what the...
Yeah, we have a picture.
No, I'm saying of what it's hiding, the fence.
Yeah.
It might help out your decision.
Okay.
What is that? Is that furniture? Is that lawn furniture?
Oh, that's
It's a lot of everything.
So it's debris, basically.
Yeah.
Let's just say that homeowner is very happy that fence went up. That particular homeowner had quite a few violations that he has cleared up. The backyard is one of those sketchy gray areas for us to enforce because it's not the side and it's not the front. So we can't truly violate him for his rear yard. So this helps everybody out.
So the fence was put up really to hide the stuff here, was that? Okay.
It's in everyone's interest to apply.
Yeah, for the membership, beyond the chain link fence is just junk.
I would like to know when the covenant says you turn the good side out. I don't understand how you can get a variance when it's not a hardship thing. That's a cosmetic thing, and I think that's something you should talk to the attorney about. When you go out there a community, there was a purpose to turn the good side out to make our community look good. And there's some gentleman back here about our home values staying up. I don't see where you would call letting a guy turn the bad side out a variance. That's a cosmetic thing. And I'd like for you folks to have the attorney to investigate that because I don't think that's a variance.
We have set a precedence here with the chain link fences and the fence before. I can remember we had one before to where they couldn't erect it that way because they couldn't remove the fence in order to have the fence company come in and put it in correct.
Right. It's a town policy to try to keep everything facing out.
Right.
Except unless behind the chain link fence. This particular fence, we're going to try to have the other homeowner, the one with the chain link fence, take out the permit for it, just so we wouldn't have to come in front of the board and ask for a variance. The new builder was just going to give it to him, just to cover his crap, but it turned out that the chain link fence was too close to the property line. So the fence is technically on the new property side, and he couldn't do that. Otherwise, we would have just saved you the paperwork of the variance and just gave the fence to that homeowner. Because in reality, what difference is to him? If he took it out, he doesn't need a variance from you because it's faced out, smooth side out.
Right.
It's all on who takes the permit out. It's basically to answer Mr. Engel's question.
I
If that
see
other
what you're
homeowner took the fence out, it's faced the right way, right? We wouldn't have to be here right now.
Mm-hmm.
So
I guess you're right with that. That's a good point.
Do I have a motion?
I make a motion that we approve the variance in the retro 2040 Jamaica Drive fence, smooth side out, next to chain link fence.
Second.
I second.
No. Okay, it's motioned and seconded to approve in retro 2014 Jamaica Drive, fence smooth side out. Is there any discussion? Ready for the question? The question is, do we approve in retro 2040 Jamaica Drive, fence smooth side in? Smooth side in. Those in favor?
Aye.
Aye. Okay, it's approved to allow the fence smooth side in next to the chain link fence for 2040 Jamaica Drive, 3-0. Okay.
6749 Kempton Street. Variance for a wisteria trellis, 3 feet from the corner of the home. Alright, so basically this is it's going to be a live fence, basically, but they need a trellis. This is not it. So this picture here is just to show you a picture of a piece of the trellis, and he's going to have columns. This is not the picture of the actual home. We just wanted to give you a picture of what the trellis will look like. Basically, it will be a live fence. The wisteria stays green all the time, so once it grows in, it's just going to be like any other hedge. The reason he's looking for the variance is because it's 3 feet back from the corner, not 10 feet back from the corner. So that's the reason for the variance.
3 feet back from the corner of his house?
Right. It says that it has to be 10 feet back from the corner of the house. Otherwise, he needs a variance. So that's why we're here today, for the 3 feet, not the 10 feet.
And the ACC approved?
Yes. Yeah. Do you have a picture of it when it's full grown in? You won't see any of the fence.
I have a picture of the
Basically,
wisteria, but
it's a live fence. It will be all green and it stays green all year.
Or purple with the wisteria.
Well, with flowers, but the leaves are green.
Okay, do I have a motion?
I make a motion that we approve 6749 Kempton Street variance for wisteria trellis 3 feet from the front corner of the home.
Do I have a second?
I'll second.
Motion and seconded to approve 6749 Kempton, wisteria trellis, 3 foot from the front corner of the home. Any discussion? Are you ready for the question? Question is to approve 6749 Kempton Street to allow the wisteria trellis, 3 foot from the front corner of the home. Those in favor say aye.
Aye.
Aye. The motion carries 3-0 to approve 6749 Kempton Street, the wisteria trellis, 3 foot from the front corner of the home. Go on.
6961 Loisburg for a driveway extension 2 feet from the property line. So obviously, just to refresh your memory, 10 feet is the magic number again. So he's going 2 feet. The purpose of the driveway extension was so he could park his boat in the rear yard. So it's not a great picture. Basically, he's just doing a shoot off of his driveway so he could get his boat into the backyard. The ACC does recommend that you approve it. The only concern we actually had was doing the extension, a driveway extension, that water runoff from the house might run off and back onto his property, the neighbor's property. And he just gave us a drawing this morning that said he's going to put drainage in to make sure all of the water runoff from the driveway will go back onto his property.
Is that in writing?
Yes, it's in the drawing we got, so it will be in his folder.
Okay.
And you're going to check up on that?
Oh, yeah.
Okay. Can I have a motion?
I make a motion that we approve the variance 6961 Loisburg Street for driveway extension 2 feet from property line.
Second.
Is it-
Motion and seconded
one-
to,
Sorry.
okay. Motion and seconded to approve a variance for 6961 Loisburg, for driveway extension 2 foot from the property line. Any discussion?
I do have a question for you. Pete. Is this within the county's permitting?
Yeah, they don't have any issues that have concrete. They'll just break up if they have to. It's just the structures that they worry about.
Okay, it's not set back from the corner water?
Anyone today? Okay, the motion is to approve a variance, 6961 Loisburg, for driveway extension 2 foot from the property. Those in favor say aye.
Aye.
Aye. Motion passes, to approve the variance for 6961 Loisburg Street for driveway extension 2 foot from the property line, 3-0. And these next ones, I would like our attorney to comment on these next two. I'm sorry, do you have an agenda?
Yes.
You do, okay.
Okay. So 2028 Bayou, basically this homeowner, it's a foreclosure, it's vacant right now. They owe approximately $1,700, and we're doing lawn maintenance. So we're basically cutting them off. Actually, this also one, I believe, had gained access from vandals, and we had to go in, actually, maintenance department, and actually fix the garage door. So I think there was a charge of like $347 just to go in and for material and fix the garage door, just so it would be open.
So what exactly are you asking?
What do you want to do with it?
Have you sent the,
Oh, yeah, oh, no, all the remediation letters are done.
Oh,
We
okay.
sent, all the violations went through.
Okay, I think, Mr. Crook, I think I discussed this, that we had a pre-mediation letter, and I sent it to your office, that we were sending out as a last step for Holly, just prior to sending to an attorney. So what you're really asking is that these be turned over to legal.
Correct. There's no more the ACC could do. We're maintaining the property, they're not even there. The fees are.
We can go ahead and enforce that.
Okay, so the motion for these would be to turn over to legal.
Correct.
Okay, can I have a motion for the first one?
Can we just do these together? Can we just have one motion for both of these violations?
You can, I could talk about the next one too, and you could do it that way. This way it's on record that I talked about both of them.
Okay, go ahead.
Okay, so 6839 Flintwood is basically the same with the landscaping. We've been doing it for a while. It is also a foreclosure. It's vacant, and they owe roughly $1,592.
Okay, I make a motion that we combine item F on the architectural list, violation process, no response to pre-suit letter, 2028 Bayou Drive, vacant foreclosure, maintenance garage door needs repair. And G, violation process, no response to pre-suit letter, 6839 Footloop Drive, vacant foreclosure, maintenance, landscaping, pie grass, weeds on Holly by the Sea, main lawn list.
I second that. Okay, it's motioned and seconded to take both of these items together as a send to legal. It's 2028 Bayou Drive and 6839 Flintwood Street. Any discussion? Okay. Ready for the question? The question is to combine the last two items of the ACC, which is send to legal, 2028 Bayou Drive and 6839 Flintwood Street, to send to legal. Those in favor?
Aye.
Aye.
Aye. Okay, the motion passes 3